hapon po sa inyong lahat. Marso na po. Here on Kababayan Today, we've got our first live show with our friends from Aquino and Loew.
This American Dream segment is brought to you by Aquino and Loew Law Firm, answering your immigration questions.
We have our immigration attorneys here to answer all your questions, so you can call us. It's our first live show of the month. Maraming salamat for being back, Mr. Richard Loew and, of course, Allison Aquino-Silva. Let's get right to it. There's a lot of news about this talk with a federal judge talking about DACA and how it wasn't able to, people weren't able to put in their petitions. So let's talk about this. What's going on?
Well, what happened is that, as you know, the Obama administration was going to go forward with the DACA expansion on February 18th. A federal judge in Texas, based on a lawsuit by 26 states, stopped that from going forward, issued an injunction. And last week, the Obama administration filed a request for the judge to lift that injunction, and also filed an appeal to the 5th District in order to have the program go forward. So right now the program is stopped.
It's on hold.
It's on hold. It's not, and until there's a resolution, either the injunction is lifted or the appeal is granted, or there's a decision in the underlying case, it's on hold. So right now there's no real expectation as to a timeline. We're hoping that within the next, hopefully, either it's going to be quick within the next few weeks, or it's going to be a few months.
A lot of people are affected by this, yes?
Yes, but just to clarify, to Richard's point, what was put on hold is the implementation of the expanded DACA and also DAPA. What the court order did not include is the original DACA program. So individuals who are qualified for DACA under the original program, they can and should still move forward with filing their applications, filing for initial grants, and also for extensions.
All right, we also got an email question from Claire. She asks, I would like to ask my case. I came here as a fiancé visa. I'm from the Philippines. I got married to my petitioner, but he doesn't want to apply for my green card. So now we've been separated for 8 months already. Can I still process my green card without him? Or shall I divorce him and marry another citizen? What is the best thing to do?
Well, this is an extremely complicated situation, but essentially, a person who comes in on a fiancé visa and marries the petitioner can go forward with their adjustment of status application in certain situations. It's a little bit complicated. There's a lot to gray areas in that, but they can go forward. What they cannot do, if a person comes in as a fiancé, they cannot get married to somebody else and then adjust or go through any other position and become a permanent resident. They are limited to becoming a permanent resident through the person that petitioned for them.
All right, so we have our first caller on the line. Sheila, ano pong tanong ninyo?
Yes, ang tanong ko po, kasi ako'y green card holder ngayon. Nakuha ko po ang green card ko as unmarried child. Tatanong ko kung dahil married po ako sa Pilipinas,
you were married in the Philippines?
Yes, natatakot po ako mag-citizen. Ano pong process ang dapat ko mong gawin para makapag-citizen po ako at ma-petition ko ang family ko sa Pilipinas?
All right. So, Attorney Allison Aquino-Silva, what can you say with the question that Sheila has asked?
And Sheila's question actually is rather common from the Philippines, because a typical situation involves a parent who is petitioning an unmarried child over the age of 21. But because the waiting periods are so long, people get tired of waiting. They go ahead and they get married, and they don't reveal that marriage when they eventually apply for their green card. And maybe they're fortunate and they actually get away with it. They get their green card, come into the United States. And now it's many, many years later, oftentimes they're still separated from their families. They don't know what to do because they worry about their green card itself.
That's right. Can she apply for her citizenship?
What she needs to do is definitely move forward with the citizenship application. This is the prime time for any individuals faced with that scenario to move forward with their case, essentially because, as you can probably see, immigration is taking a somewhat relaxed attitude toward individuals right now. So
that's right. So now is the time to strike while the iron is hot, so to speak. We have our next caller on the line, si Ellie Jo. Ellie Jo, ano pong tanong ninyo?
Yes, I'm a green card holder, and I get married from a tourist visa, but she's out of status. But she can change the status even I'm a green card holder. The thing is, I don't want to become a U.S. citizen.
Okay, so the question is, he has a green card, but he doesn't want to apply for his U.S. citizenship.
This is again a little bit of a complicated situation. As a permanent resident, you can petition for your spouse, but unfortunately, because she's out of status, she won't be able to adjust her status here in the United States unless he's a U.S. citizen.
That's right. So
it's a little bit of a back and forth.
The best situation is to apply for your citizenship.
The only other way would be if she would somehow 245I eligible. She had a petition before April 30th, 2001, and then she wouldn't have to do that, but we're a long way from 2001 these days, so very few of those left.
Okay, so please, I request that you all give us a call, 1-800-553-5724. Our immigration lawyers from Aquino and Loew are here to answer all your questions. We'll be right back on Kababayan Today.